Ms. Blatt, if we accept your arguments when it's applied to sovereigns as such, is there any way to distinguish those arguments when it comes to a 51% commercial enterprise that may or may not even be identified as associated with the sovereign, but the sovereign owns one more share than to form a majority?
Yes, our definition of an instrumentality is it has to be created and designated as such by the sovereign and ownership and control. So you wouldn't have 51% doesn't get you there. But
why not? I mean, it's 51% of control and ownership and all that.
Because I think for just, anything kind of even arm of the state or federal instrumentality, it's important to have the designation by the government and created. In other words, I don't think.
So you're saying they would choose? There's some where they're going to say this is us and others where they're going to say we just happen to own majority of the shares?
That's what Congress does. And this court has always deferred to Congress's judgment when it designates a federal instrumentality by statute. What I'm trying to prevent is a situation where if a foreign country just bought a U.S. company and had control, I don't think that means it's a foreign instrumentality. If it's an organically created by the foreign country and, here it's an affiliate of the Treasury Department or sort of the Ministry of Treasury, so it's much more than that. So I don't think it can just be this 51%. But cases like, LeBron, Amtrak, Thacker, FDIC versus Meyer, you've had a million cases involving federal instrumentalities, and it's always been enough that Congress designated it as such, and it is a sovereign, but for the sue and be sued clause, which waives the immunity it would otherwise have. And again, what worries me and why I think Congress should have a vote is I don't think, not every president in every foreign country may feel the way our president does, and all we're saying is that Congress should speak clearly before opening up federal courts to that jurisdiction. Once Congress has its say-so, then there's nothing you can do about any prosecution. The government gets to decide who to prosecute. But usually there's congressional authority, and then you have a bunch of cases saying sovereigns, including foreign sovereigns, aren't persons. It's just a presumption that general statutes don't include the sovereign. They don't